Will the court officer please call the case?
Good morning, Your Honours. The special session marking the formal opening of the Judicial Year 2022 is now open. La session spéciale de la Cour pénale internationale marquant l'ouverture officielle de l'année judiciaire 2022 est maintenant ouverte.
Thank you very much. Madam Guest of Honor, President of the Kosovo Specialist Chambers, dear fellow judges, both here in the courtroom and in the remote connection, Madam President of the Assembly of State Parties, Madam Vice President of the Assembly of State Parties, Mr. Prosecutor, Mr. Registrar, Madam President of the ICC Bar Association, esteemed representatives of national, regional, and international judicial institutions, states, civil societies, international community, and the general public following this session via webcast. I welcome you all to the solemn hearing on the occasion of the opening of the Judicial Year 2022 of the International Criminal Court. I am joined at the bench by the first Vice President of the Court, Judge Ibanez, and by Judge Perrin de Brichambault, exceptionally replacing the second Vice President, Judge Mindua, who was regrettably prevented from joining us today. Under normal circumstances, there would be more people in the courtroom. Most notably, all 18 judges of the ICC would be physically present instead of connecting remotely to the hearing. However, due to the continuing COVID-19 pandemic, we must observe precautions that make it impossible to do things quite in the same way as we are used to. I am grateful to my colleagues that they are nevertheless with us, as each one of them forms a key part of this court as a judicial institution. Indeed, one of the primary purposes of the symbolic hearing is to underline and recall that the ICC is a court, an independent judicial body. As such, it is fundamentally different from most other international organizations. There is a reason why we convene in a courtroom and not a conference hall. It is also an occasion to stop for a moment to take a brief look back, but even more importantly, to focus our minds on the work that awaits us in the next year. 2022 is a special year for us, as it marks the 20th anniversary of the International Criminal Court. On the 1st of July, it will be 20 years since the entry into force of the court's founding treaty, the Rome Statute. There will be many opportunities during this year to reflect on the road the ICC has crossed so far and what awaits us in the future. What is clear after the ICC's first 2 decades is that the court has become a permanent feature of the international legal and judicial landscape. At the same time, there are countless open questions about the ICC's future. How much can it advance the fight against the impunity in the long run? Will state provide the court with sufficient resources and the full cooperation required for the effective discharge of its mandate? Will national jurisdictions step up to the plate in accordance with the principle of complementarity to prevent the ICC from being overburdened? Will it be possible, and when, to make the Rome statute system more universal than it is today with 123 state parties. Time is too short today to scratch even the surface of those intriguing questions. But I will say this: the ICC is on the good path. The court is doing more than ever in the concrete delivery of justice through investigations, trials, and reparations. Numerous significant decisions were issued last year, including 2 major appeal judgments, 1 trial verdict, 1 sentencing decision, 1 reparation order, 3 decisions on the confirmation of charges, 1 decision authorizing an investigation, so on and so forth. Thanks to the dedication and hard work of the court's staff, the proceedings in our courtrooms have not stopped at any point during the pandemic, despite the significant challenges. Last year, a total 753 hours of courtroom hearings were held at the ICC. That is a remarkable number considering the circumstances under which we have been working. In 2022, the number of courtroom hours will, in all likelihood, further increase as we head towards an unprecedented level of trial activity in the court's history. First of all, the trials in the Al-Hassan case, in the situation in Mali, and the Yekatom Gaisona case, in the situation in the Central African Republic, will continue. The trial in the Gicheru case, in the situation in Kenya, is set to begin on 15 February on charges of offenses against the administration of justice. Then the trial in Abd al-Rahman case is set to commence on the 5th April. This will be the ICC first trial concerning the situation in Darfur, Sudan. And finally, charges have been confirmed also in the 5th case, the Said case. However, this decision is not final, and to date has not been set the commencement of the trial. Dear colleagues, ladies and gentlemen, these and other activities of the court, ranging from preliminary examinations to appeal proceedings and the many functions surrounding trials, such as witnesses protection, will keep us extremely busy in the year 2022. And while we had hoped to return to the normality by now, the regrettable fact is that we will have to continue working under the unpredictable circumstances of the pandemic for the time being. This will be demanding for all of us, and it only highlights the importance of our efforts to improve the well-being of all staff as part of the wider review process aimed to enhancing the court's operations. With those words, I conclude my opening remarks. Before I give the floor to the prosecutor, we will hear a musician intermezzo performed by Sene Percussion, a drumming group based in the Netherlands, led by Mr. Abdoulaye Okesene from Senegal. Please begin. Thank you very much for the wonderful performance. And now I would like to invite the ICC prosecutor, Mr. Karim Khan, to take floor.
Mr. President, Judge Hofmansky, Vice President Ibanez, respected Judge Brishambo, respected honourable judges of the ICC, our dear guest of honour, President of the Kosovo Special Court, Judge Trendafilova, President Silvia Fernandez de Gamendi, President of the Assembly of State Parties, Excellencies, ladies and gentlemen, friends, really that's the most important thing to emphasize, friends in the cause of international justice, dear Mr. Registrar and President of the ICCBA. It's really a great honour to say a few words at the opening of the Judicial Year. It's the first time I've had this opportunity, and it's not an unimportant event. Opening of judicial years are regular parts of many national jurisdictions. They are a time for reflection, a time for recalibration, a time for coming together with renewed purposes. And I think this is something that is very much to be encouraged and applauded. In fact, today, with the very uplifting music from the, which I'm very grateful for, it's a sign of solidarity. Here we are, judges, diplomats, prosecution, representatives through the President of the ICCBA, of the legal representatives of the victims and the defence, the registrar and all court staff, united by a common purpose, which is the Rome Statute. It is also important with the passing of years and the marking of new judicial years to recall a simple reality, much more acutely felt perhaps in these COVID times, about the very brief sojourn that we all have on this planet. It is a time that we have which is a blessing and a chance to make a difference. And we can do that by acting independently and impartially and with fidelity to something far more important and far more lasting in our than our transient existence, which is the law. The law remains an anchor that will stabilize the ships of state in inclement weather. And it is worth recalling in this court, dedicated to accountability for the crimes that it focuses on, to remember that as we speak, so many on deck remain battered by abuses, unfairness, and injustice. It's also a time to mark change. Unfortunately, Deputy Prosecutor James Stewart is not able to be with me today, but he will be leaving after 9 years of service in 2 months. And in March, God willing, we'll be welcoming 2 new deputies. So it's a time of renewal and change. The task of change, of renewal, is essential. The task that I've inherited is to try to build upon what is solid and what is working in the office, but to improve that which is not. Trying to help the office become more credible, more effective, and more efficient, and so that when I bequeath this office, when my successor takes over, he or she can also address and build and repair what is broken, to take the law and the spread and the mantle of accountability wider and more effectively. We are, of course, facing a reality that the law in every system, and perhaps in the international arena more than ever, is a work in progress. But we stand on the shoulders of giants, not just those judges and prosecutors of Nuremberg, or those judges of the ad hoc tribunals or international courts, but from many great national jurists, not just judges, advocates like Thurgood Marshall, and not just from contemporary times, those that have been engaged in anti-apartheid, anti-slavery, anti-colonialization movements, particularly in the 1950s, 1960s, and 1970s. We go back to Justinian and the jurisprudence of Rome. All of this shows that we are united. No people are left behind. We look at the laws in the Talmud, in the Bible, in the Quran, the teachings of Confucius and Krishna and Buddha. This is important because the Rome Statute that we have the honor to serve incorporates aspects that are the shared inheritance of every man, woman, and child alive, whether they are Rome Statute nationals or not. In this period, I hope to forge better relationships, forge more stronger bonds of collaboration with national counterparts, because the scale of crimes that we have to deal with are so widespread, are so pervasive, that that is the only model that will work. I hope we can improve quality. It will not happen immediately, but in time I hope some of the results of that will become increasingly manifest. In the courtroom, I am, of course, and members of my office are equals. As prosecutor, of course, I am head of an organ of the court, but in the courtroom we are absolutely equal with the legal representatives of the victims and the defense, and I look forward to constructive, honest engagement with them, bound by our independent responsibilities, but realizing that our ethics also require us to try to ensure expeditious trials. We should agree facts when they are not reasonably in dispute. That is also a matter of ethics that the prosecution, defense, and legal representatives of the victims must uphold. Your Honours, you are above all of us. You and your fellow judges settle disputes, decide the merits of different submissions. It's a heavy task. It's a heavy responsibility for which, of course, you have our appreciation and our thanks. It is oft said that judges try cases, but cases try judges. And in this area, perhaps that is particularly noteworthy. The one request I perhaps make is this, that after 20 years of evolution, we are now a mature institution. I think defense, legal representatives for the victims and prosecution really do increasingly ask for greater predictability in procedural decisions. We can't have, now after 20 years, different decisions on proofing or no case to answers in different chambers of the same court. Credibility and confidence comes with predictability, and I hope that is something that can always be worked towards. So, Your Honour, my final remarks is this, that we are united by the law. We are committed by our particular responsibilities. We hopefully will do better together. But at the end of the day, beyond the almost imperceptible weight of the robes that we all wear in this courtroom, we should feel much more acutely and far more heavily a real weight of expectations that victims and survivors and states and humanity at large have in this institution, in which all of us must play our part. I am committed in this new year and in my term to serve as a colleague with all participants that make this ICC system work, and hopefully to serve with you to take forward the very noble aspirations and requirements of the Rome Statute. Thank you so much.
Mr. Prosecutor, thank you very much for your words. And now I invite Ms. Jennifer Naouri, President of the ICC Bar Association, to take the floor and to make remarks. Please, the floor is yours.
Merci, Monsieur le Président.
Mr. President, Madam President of the Kosovo Specialized Chambers, Madam President of the Assembly of State Parties, Madam Vice President, Mr. President of the Court, Honorable Judges, Vice Presidents, Mr. Prosecutor, Mr. Registrar, Your Excellencies and distinguished guests, the beginning of the judicial year is a special moment, a time to take stock of the past and look to the future. It is a moment when we, the parties and participants before the court, render accounts and attempt to anticipate what lies ahead. It is an honor and a privilege for the ICC Bar Association to speak on behalf of independent counsel and support staff representing victims, accused persons, witnesses, states, and amicus curiae before the ICC. As we were reminded this morning, it is important to listen to one another and to learn from one another. The past year has been a very fruitful year for our institution, despite the difficult health situation. First of all, the ICCBA amended its constitution so that the elected representatives of the support staff can now be part of our executive committee. This is an important victory because it has made the ICCBA a more representative institution, thus giving a true voice to all those who have worked with such dedication, often under difficult conditions within the legal teams. They are the ones who allow many trials to go ahead, thanks to their professionalism and their resilience. Secondly, the ICCBA has played its role as the key interlocutor in many operational discussions. In particular, the ICCBA played an active role in many discussions having to do with reform of legal aid, which is one of the foundations of fair, equitable, and impartial justice. The ICCBA worked closely with the facilitator of the Hague Working Group, Her Excellency the Ambassador of El Salvador, and we wish to thank her for beginning this constructive dialogue between the ICCBA, states parties, and key holders in the court, in particularly representatives from the registry. And we look forward to continuing our cooperation in 22. We also thank the registrar and the director of the Division of Judicial Services, with whom we work closely. Thanks to various discussions, we have been able to establish the principles that will allow us to make progress on the issue of legal aid. Our association's priorities will continue to be ensuring the principle of equality of arms between prosecution and defense, and effective representativity of victims, which is dependent upon solving the issue of taxation of income by the host state. Secondly, improving working conditions so that we can hit upon a legal aid policy that ensures access to suitable social protections, such as maternity leave. This is particularly important since the legal teams are, for the most part, made up of women. Regarding gender issues, we are very happy to make mention of the remarkable work done by our working group on gender parity, equality, and well-being in the workplace. Continuing, this work will be one of our central points in the year to come. And as the first woman president of our institution, I am particularly aware of the great responsibility that I have been entrusted with. I have been meeting with the ICC focal point for gender equality, and we have already cooperated on some internal projects within the court, and we will continue our cooperation. I am very privileged to have been designated International Gender Champion, and this year we will work hard to respect the pledges that we have made. The objectives will be to continue advocating for a safer workplace free of any kind of harassment. And we will also advocate for consideration of gender sensibilities in the courtroom for victims and witnesses. The ICCBA will continue to work tirelessly with the court on these crucial issues and will be a partner to improve things for all those who work for justice on a daily basis, be it the prosecutor, the defense, the victims, or the registry, because together we can and we must do better. In 2022, we will continue our advocacy work so that legal teams can carry out their mandate in good working conditions, particularly when it comes to matters such as the need for cooperation, for provisional release and serving sentences, the need for funding, for the family visit fund that allows detained people who are presumed to be innocent to enjoy family visits. And finally, ensuring the diversity and effectiveness of the representation of victims at all stages of proceedings. The ICCBA has shown this year once again that we are an important partner of the court in its efforts to achieve the universal goals set out in the Rome Statute, and we will continue to be a trusted partner of the court in the future. Thank you very much.
Thank you very much, Ms. Naouri. I give the floor next to the Registrar of the Court, Mr. Peter Lewis.
Madam President of the ASP, Madam Vice President, Mr. President of the Court, Madam Vice President, Judge Peran, Your Honours, Madam President of the Kosovo Specialist Chambers, Mr. Prosecutor, Madam President of the ICCBA, Excellencies and colleagues from the Court who are joining us remotely. It is a great honour to address you today on the opening of the 2022 Judicial Year. A new Judicial Year provides an opportunity to reflect on the year behind us, as well as to look forward to the year ahead. Although we did not have a formal opening of the Judicial Year in 2021, we did, nevertheless, have a very full year of judicial activity with substantial pre-trial, appellate work, as well as, of course, of the trials. Behind that simple statement of activity lies a more complicated story of the hard work, resilience, flexibility, and resourcefulness of the people of the court and those who support us. Despite COVID, we found ways to bring witnesses to the court or to the places where they could give remote evidence, to protect and, if necessary, relocate witnesses and their families, to support defence missions and missions for legal representatives of victims, to provide family visits for detainees, to obtain cooperation from states and international organisations, to arrest a suspect, to deliver reparations, to identify victims and organise outreach activities, and much, much more as well. And all of this was achieved in a significant year of change in the leadership of the court at almost every level: political, judicial, prosecutorial, at the ICCBA and the board of the Trust Fund. Maintaining and indeed improving our performance through the pandemic and at a time of significant change, organisational change, is a strong indication of the growing capability and maturity of the court. Now, looking forward to the year ahead, our 20th anniversary year, we have many challenges to meet. Our present workload, particularly with 5 cases at trial stage, means we're going to be very busy in the court for all of 2022. The scale of victim participation in some of these cases is going to be much greater than we have dealt with before. The size of the reparations work of the Trust Fund is already proving to be of a different scale than that previously encountered. Many of the situation countries we are working with are going through a period of transition, and in some cases, significant transition. COVID is likely to impact on our operations, at least for the next few months. Nevertheless, we can take confidence as we approach these challenges. We have proved our resolve, resilience, and adaptability. We have the strong support of our state parties to deal with the increase in our caseload and to provide cooperation. Above all else, we are facing our 20th anniversary year with a renewed sense of confidence in the importance of our mission and our ability to meet whatever challenges are set before us. Thank you, Mr. President.
Thank you very much, Mr. Registrar. I will now invite the musician group Stand Up Percussion to perform for us for the second time. Please. Thank you very much. Let us give an applause to these excellent musicians. Thank you. I now have the great pleasure to introduce today's guest of honors and keynote speaker, Judge Ekaterina Trendafilova, President of the Kosovo Specialist Chambers. Judge Trendafilova, a nationality of Bulgaria, is a real veteran of international criminal law. From 2006 to 2015, she was a judge of the ICC, serving in the pre-trial division, but also sitting on the first two final appeals of the court. As such, Judge Trendafilova made vast contributions to the ICC's work during a critical period for the court's growth. Since 2017, Judge Trendafilova has been the first president of the Kosovo Specialist Chambers, leading that institution's development from its early stages. We are truly privileged to have the opportunity to hear President Trendafilova's reflections on current issues in international criminal law. President Trendafilova, you have the floor.
Dear Judge Fernandez, President of the Assembly of States Parties, Vice President of the Assembly of State Parties, dear President Hofmansky, dear Vice President Ibanez and Honorable Judge Perandi Bruchambeau, dear fellow judges, Mr. Prosecutor, Madam President of the ICC Bar Association, Mr. Registrar, Excellencies, and dear musicians. I enjoyed very much your music. Thank you. I really would like to start with words of thankfulness to the President of the International Criminal Court, Judge Hofmansky, who kindly invited me to mark the official opening of the Judicial Year. I feel honored by this invitation. It is also emotional to be here today at the seat of the ICC, where I was privileged to spend 9-year term of office as one of the first judges elected to the World Criminal Court. The ICC will always feel like home to me, and I remain passionately committed to its mandate and success. Well, the pandemic, unfortunately, continues to impede us from gathering in person. Our shared commitment to the field of justice and to the rule of law has not prevented us from working and meeting virtually as we do now. It is very important, as was already underlined, to solemnly and proudly mark the start of the new judicial year and to send the message that courts and tribunals stand firmly by their duty to ensure independence, impartiality, and fairness in the discharge of their mandate, regardless of the challenges facing them. Justice carries on even in direst of circumstances if we, those with our shoulders at the wheel, keep pushing forward. It is especially poignant to be able to open the judicial year here in The Hague, the city which hosts an impressive number of judicial and other international institutions. It has become known as the city of peace and justice and the legal capital of the world. It is the city where the famous Hugo Grotius and Baruch Spinoza resided, where the first peace conference took place in 1899, leading to the creation of the Permanent Court of Arbitration, which in turn led to the building of the beautiful Peace Palace, the home of the International Court of Justice today. The past year has been marked by important developments for international justice that must be noted. As President Hofmanski just said, the ICC made significant progress with seminal appeal and trial judgments, pre-trial decisions related to confirmation of charges, authorizing oath investigations, reparation order as well. Last year, the ICC was also busy advancing the judicial activities for this year, 2022. As emphasized by the President, we will witness this year an unprecedented level of trial activity in the court's history. In addition, the ICC was committed to analyze criticism addressed to it, and most importantly, contemplated best approaches to respond thereto. Last year, Mr. Karim Khan, the newly elected ICC prosecutor, assumed his duties ambitiously towards the contribution of his office to international justice. I should also recall some other developments beyond the ICC, starting with closing the case against Ratko Mladic with a seminal appeals judgment, and also 2 trial judgments issued by the successor institution to the Rwanda and Yugoslavia tribunals. At my own court, the Kosovo Specialist Chambers, 1 new accused was arrested last year, bringing the total number of accused to 8, and 2 cases already proceeded to trial. Regrettably, the Special Tribunal for Lebanon faced unprecedented financial hurdles and was forced to shut down the majority of its activities in record time, leaving only the appeals chamber to render its judgment. This is a cautionary tale for us all, of which we all should stand ready to learn. The road to the establishment of these courts, with their successes and tribulations, has been a remarkable one. The need to respond to atrocities that deeply shock the conscience of humanity galvanized the foundation of international and internationalized courts and tribunals. Indeed, their creation and mandate outside the traditional structures of states is probably one of the most significant changes in international law in the past century. We are no longer at a time when we question whether individuals who committed crimes of concern to mankind will be brought to account. The existence of these courts further results in a comprehensive record of such grave crimes through the testimony of countless witnesses and other evidence presented, and ensures that these heinous acts do not fade away unnoticed. The momentous development in the field of international justice was the adoption of the Rome Statute of the Permanent International Criminal Court in 1998, 17 July. The road to the ICC becoming operational, which required at least 60 ratification of its statute, was not without very real challenges and took place against the backdrop of events that would forever be seared in the memory of humanity. In September 2001, the Twin Towers fell. The smell of sulfur remained in New York's air. Smoke plumed from ground zero. Yet, the world convened to keep building this court. The United Nations continued hosting the work of the Preparatory Commission for the ICC. The next spring, the 60th ratification was deposited. The international community sent the unequivocal message that justice will neither be delayed nor stopped, no matter how difficult the circumstances. The ICC, however, is not alone in the arena of international justice. One has only to think about the ICTY and ICTR with a combined 254 indicted individuals. We have also seen the proliferation of other international, hybrid, and regional courts to address accountability for conflicts that either occurred before the temporal or fall outside the subject matter jurisdiction of the ICC, or are established to deal with specific circumstances on a smaller scale. To name a few, the Special Court for Sierra Leone, the Extraordinary Chambers in the Courts of Cambodia, the Extraordinary African Chambers in Senegal, the COSFU Specialist Chambers. I'm sorry, I'm not exhaustive. We should also recall mechanisms created to assist in the prosecution of individuals having committed widespread atrocities, like the International, Impartial and Independent Mechanism for Syria and Myanmar, the United Nations Investigative Team to promote accountability for crimes committed by Daesh, as well as more localized national initiatives, including the war crimes offices established throughout the former Yugoslavia. We should also not leave unnoticed the determination of national authorities on the basis of universal jurisdiction to prosecute and put on trial individuals for international crimes they allegedly committed. Some states such as Sweden, Norway, France, the Netherlands, Germany, Belgium, Finland, I'm still not exhaustive, had been active in conducting investigations and prosecution on the basis of universal jurisdiction. Just last week, a German court sentenced a Syrian colonel to life imprisonment for crimes against humanity in a landmark case based on universal jurisdiction. In this regard, it should be recalled that the increase in prosecution of international crimes before national courts reflects the very sense of the principle of complementarity, which is the cornerstone of the Rome Statute. The ICC encourages and assists domestic institutions in carrying out investigations and prosecutions for serious international crimes through their independent, impartial, and fair national proceedings. Each of these international, regional, and hybrid judicial institutions, as well as domestic authorities, have enhanced and further shaped the course of international justice. International justice, as it stands today, would not have come to fruition without the building blocks of each one of these institutions, no matter how central or limited in mandate they may be. At this point, I would like to share with you what years ago my PhD supervisor, a wise man with an exceptional legal mind, told me. If we imagine international justice as a building to be constructed, some will lay only a few bricks. Someone else will contribute 100, while others will build an entire floor. In the end, though, the building will not be constructed only by those who built the entire floor, but by concerted joint efforts of all. This metaphor sends the message that the contributions of all those committed to justice must be acknowledged, valued, and encouraged. Moreover, we are all members of the same family. The success or setback of any of our institutions affects international justice and the perception thereof. Therefore, courts and tribunals must learn from and listen to each other with open minds. Importantly, courts should also be supportive of each other, in particular in times when we have to meet the exigencies of difficult periods. If one of us fails, we all fail. Eventually, justice fails. We should not forget the warning of Immanuel Kant, who said, if justice perishes, human life on earth has lost its meaning. The first courts and tribunals were tasked to blaze the trail of international justice, and they deserve our honor and appreciation. However, the field is not static, it evolves. We must continually seek ways to improve in order to grow, not only in terms of efficiency, but also legitimacy. Court should analyze the criticism leveled at previous such institutions, drawing on best practices and developing innovative approaches to ensure that justice is done in the most efficient and effective manner while upholding the core principles of independence, impartiality, and fairness. For example, the drafters of the Kosovo Specialist Chambers, legal framework, and the judges of our institution have sought to benefit from the experiences and lessons learned of courts that preceded our court. With some of its innovative concepts, the KSC could also make its humble contribution to the field of international justice. I will refer only to some of the novel approaches, such as the new system for the selection of judges, the assignment of judges to perform judicial duties, enhancing the role of the single judge to ensure the efficient conduct of proceedings, strict timelines, however applicable not only to the parties but also to judges, more specifically on the duration of the pretrial proceedings and the issuance of trial judgments. The management of proceedings is meticulously regulated as a central duty of judges with an eye towards efficiency. We are all aware that courts are in the limelight and are all subject to scrutiny, and rightly so. We must uphold the high standards in the delivery of justice. We should, however, not be quixotic. Some reflections on our performance are positive. Others are critical. At times, they could be antagonistic or distortive, with the aim to create an untruthful picture of our performance, to diminish the respect for the values we symbolize, to subjugate or to abolish us. We should not be taken away by compliments, for we risk to lose the sharpness of our judicial scrutiny and conscience. We should also not disparage the critic. Particular attention should be given to constructive feedback without succumbing to speculative allegations or even threats, as the case at times may be. We should remain calm but strong. In such circumstances, we should think of Shakespeare, whose words are telling at all times: be just and fear not. The ICC, like other courts and tribunals, has faced scrutiny and critique over the years. The ICC has taken seriously the concerns expressed and has embarked on a variety of decisive steps to improve concrete areas and to demonstrate that it remains adamant in the pursuit of justice and a staunch pillar in the fight against impunity. The new prosecutor, too, has taken concrete action to address concerns directed at his office. Recently, he closed some preliminary examinations which were pending for many years and concluded bilateral monitoring agreements with these states, thereby continuing to follow the situation and providing assistance to domestic investigations and prosecutions. In March, the ICC appointed its full-time focal point for gender equality, a very important undertaking. The ICC is without any doubt unique in the field of international law. It is the one court with a global focus and broadest mandate. It is the world's preeminent standing court to respond to current and emerging conflicts or crises, which stands as a bulwark against impunity. As a former ICC judge, and having witnessed firsthand the commitment and passion of professionals working here, I'm confident that the ICC will continue to grow and will come out all the stronger as the one permanent global court. That being said, the criticism leveled, including at the ICC, cannot be laid solely at the feet of courts and tribunals. While there is a lot we can and should do to improve efficiency of proceedings and the management of our resources, states should equally take responsibility by supporting us both practically and symbolically. Being entirely independent and impartial, our courts still rely on states' cooperation, which we need due to our specific nature, limited resources and capacity, as well as lack of police force to assist in effectively carrying out our mandates. Therefore, the responsiveness and engagement of states is crucial for us to fulfill our mandates and to fortify the foundations of international justice. We expect states to speak with one voice in condemning those who refuse to cooperate with courts, or worse, who actively act to weaken us, to imperil our operation or even our existence. It should be clear that such attempts will not abate, and states have an important role in this regard by strongly voicing that there will be no tolerance for those who seek to shelter or avoid holding accountable individuals accused of having committed the most egregious international crimes. The success of courts and tribunals depends also importantly on judges. Indeed, as judges, we have a tremendous responsibility to ensure the independence and impartiality, as well as the efficiency and fairness of proceedings. The postulate of Aristotle is well known and often resorted to when it comes to law. Law is reason without passion. However, applying the law in our daily work requires passion, so that we commit to our duties assiduously and with full devotion, constant enrichment of knowledge and experience, and sacrifice of personal comfort. We judges must also abide by the high standards of judicial ethics, both inside and outside the courtroom. Accountability does not extend only to those who appear before the bench. Judges are expected to act with dignity and integrity and with respect to everyone. The expectations of and constraints for judges are highest, and the judgment of society will be merciless if judges do not adhere to the standards of the office they hold. I would like to conclude sharing again with you the experience I had some years ago in a chilly December afternoon at the Speaker's Corner in Hyde Park. I happened to be the only audience to a sermon of an elderly Asian monk who, amongst other topics, shared what his mother told him in his youth. If one day you do not have a challenge, you should notice this. If the second day you do not have a challenge, you should start worrying. If on the third day you still do not have any challenges, then you must kneel and pray passionately to God to send you challenges, because only by overcoming challenges can we become stronger. I don't remember the rest of the monk's words, but his mother's advice made me think of the field we're all so ardent about, the field of justice. We should not be discouraged or be fearful of challenges. They are invariable part of this field. And indeed, when overcoming them, we become stronger. Even the most brutal threats will not bend our will to fulfill the mission entrusted to us. We should face challenges with the full force of our collective experience, our joint wisdom, tremendous commitment, and hard work. Our success, no matter the challenges we may face, serves as a stark warning to all those who may contemplate committing such crimes, that they will be held accountable and that justice will prevail. I end by extending to all of you my warmest wishes for good health, continuous wisdom, and fortitude for the judicial year ahead. Thank you.
Dear President Trendafilova, thank you very much for your truly inspiring speech. Your words are a powerful reminder of why we do what we do in the service of international law, justice, and the protection of human dignity. Thank you again for accepting the invitation to address us today. Dear colleagues, ladies and gentlemen, today's hearing has given us the benefit of hearing insightful remarks, both on what we do at the court as well as what the support the court requires to discharge its judicial mandate effectively and independently in accordance with the law. I cannot stress this last word enough: in accordance with the law. That is at the core of our task as a judicial institution. It is through the application of the law that we must contribute to the court's noble mission. On that note, I invite all of us to redouble our commitment to the work that we are privileged to do in the service of international criminal justice, for the sake of humanity, for the sake of victims, and for the sake of the rule of law. I hereby declare the Judicial Year of 2022 of the International Criminal Court open. The hearing is now adjourned.
All rise.